Lesson 2. Dissolution and Nullity. It was necessary that these judges, so degenerate, be admonished, so that they would not break with such hasty audacity the sacred bond of marriage. News of this depravity, which must be abolished, has reached us from various quarters, and even examples have been cited of some men who, due to the excessive haste of the judges in declaring marriages null, after taking a first, second, and third wife, while these first wives were still alive, had gone on to contract fourth marriages. Similarly, there have been cases of women who, after having a first, second, and third husband, while these first husbands were still alive, even joined the fourth, not without a scandal to the weak and abhorrence from all the righteous, who grieved that the sacred bonds of marriage were thus despised and recklessly broken. Benedict XIV, De Miseratione, 1741. 1. Dissolution. You have heard it many times before. Catholics don't believe in divorce. There is no divorce in the Catholic Church. Indeed, in canon law, we do not accord any effect to civil divorce. In other words, when a civil judge issues a decree of divorce, the spouses are still married in the eyes of the Catholic Church. However, regardless of our opposition to civil divorce, we do dissolve some matrimonial bonds in the Catholic Church. Only sacramental and consummated marriages are absolutely indissoluble. Other marriages can be dissolved in some exceptional circumstances. Dissolution means the end of a marriage. The bond ceases to exist at the time of the dissolution. Dissolution is different from nullity. When a marriage is invalid, the parties were never really married. When a marriage is dissolved, its validity is not questioned. Dissolution cases are handled with administrative processes. Declarations of nullity are handled with judicial processes. The Catholic Church has 3 dissolution processes. Non-sacramental marriages can be dissolved through the Pauline privilege or the Petrine privilege. Unconsummated marriages may be dissolved through the superrato process. The name comes from the Latin processus super matrimonio rato et non consumato, that is, the process about the sacramental and non-consummated marriage. Pauline. Pauline privilege takes its name from the Apostle St. Paul, who says in the first letter to the Corinthians, "To the rest I say this, I, not the Lord. If any brother has a wife who is not a believer, and she is willing to live with him, he must not divorce her. And if a woman has a husband who is not a believer, and he is willing to live with her, she must not divorce him. For the unbelieving husband has been sanctified through his wife, and the unbelieving wife has been sanctified through her believing husband. But if the unbeliever leaves, let it be so. The brother or the sister is not bound in such circumstances. God has called us to live in peace." According to our tradition, in this passage, the Apostle authorized the dissolution of a natural marriage in some circumstances. Currently, the law establishes the following requirements for the application of this old privilege. First, two unbaptized persons get married. Second, one of them receives baptism after the wedding. Third, the unbaptized spouse departs morally or physically. Fourth, the baptized spouse celebrates a new marriage. The Pauline privilege requires that the former spouse remains unbaptized at the time of the second wedding. In practice, this can be difficult to prove. Many petitioners cannot find their first spouse or cannot count with any help from them at all. We also need to make sure that the first spouse departed physically or morally. Physical depart is the separation, but there is no physical separation if it is justified, for instance, as a reaction to an affair. Moral depart happens when the unbaptized party does not allow the baptized party to live without affront to the Creator, that is, to live in accordance with the faith. While it is not a requirement for liceity, the law requests to interrogate the unbaptized party, asking if they want to be baptized and if they want to live in peace with the Creator with their current lawful spouse. The petitioning party must receive baptism after the first wedding, but before the second wedding. Note that baptism may take place after the separation. Actually, many of our Pauline cases come from unbaptized RCIA candidates. Once it is clear that all the requirements are met, the baptized party is admitted to a new wedding, and the former marriage is dissolved with the new exchange of consents. Pauline cases are not formal processes, strictly speaking. The law does not mandate a specific process for Pauline cases. It is part of the prenuptial investigation. The local authority has to make sure that all the requirements are met before admitting to a new wedding. This can be done in different ways. In Atlanta, the bishop has entrusted Pauline cases to the Metropolitan Tribunal. Petrine. The Pauline privilege is for a very specific case of natural marriage. But the Pope has the power to dissolve all non-sacramental and consummated marriages in favor of the faith, in favorem fidei. This broader type of dissolution in favor of the faith has been called Petrine privilege because it is the Pope, the successor of Peter, who grants it. This privilege applies to two types of marriages: non-sacramental marriages and marriages that became sacramental after the wedding and have not been consummated. You already know about the sacramentality of marriage. A marriage becomes sacramental or ratified when two conditions are met: baptism of both parties and valid marriage. The order of the factors does not alter the product. If baptism takes place after the wedding, the marriage becomes sacramental as soon as both spouses are baptized. The other case is a little more difficult. The marriage was not sacramental at the time of the wedding. It remained non-sacramental until the definitive separation of the spouses. It became sacramental but was never consummated. The norms for instruction of favor of the faith cases are available on the Vatican's website. These norms include other requirements. For instance, the dissolution is not granted to unfaithful or abusive spouses. For your convenience, Here is a summary of the requirements for the process. 1. The marriage was non-sacramental at the time of the wedding, or if the marriage became sacramental afterward, it has not been consummated. 2. It is possible to prove the non-baptism of at least one party. 3. There is no possibility of resuming the partnership of conjugal life. 4. The petitioner was not exclusively or predominantly the culpable cause of the breakdown. 5. The intended spouse was not at fault in provoking the separation of the spouses. 6. The marriage was not celebrated thanks to a previous dissolution in favor of the faith. 7. The petitioner wishes to marry in the Catholic Church. 8. The intended spouse is free to marry in the Catholic Church. 9. The non-Catholic petitioner or intended spouse is willing to allow the Catholic party the freedom to profess his or her own religion and to baptize and educate their children as Catholics. 10. The Catholic petitioner or intended spouse will remove the dangers of defecting from the faith. 11. No public scandal will result from the dissolution. In both petrine and non-consummation cases, the process has two phases. First, at the local diocese, we perform the instruction. We gather all the testimony and documents pertinent to the case. Then we send the acts to the Holy See, the only one with authority to decide these cases. We are merely instructors. Only the Pope can decide and grant the grace. Superrato. The third dissolution process is for sacramental marriages that were never consummated. Sometimes the spouses don't even have the chance to consummate. This would be the case of a groom who leaves for good right after the wedding. It is also the second type of petrine case which can be considered under both processes. Proof of non-consummation can be tricky when the spouses had time alone together. This proof is usually achieved through sworn interrogations, but depending on the case, a medical examination may be needed. 2. Nullity. We are about to cross the Rubicon between dissolution and declaration of nullity. Behind us are the three paths available in the Catholic Church for matrimonial dissolution. They apply to natural and unconsummated marriages. Before us, we have the rest of marriages. For sacramental and consummated marriages, dissolution is not an option. There is only one option left, a declaration of nullity. While the right name is declaration of nullity, you are probably familiar with the term annulment. This expression seems to imply that the judge makes the marriage invalid, while in fact the nullity of the marriage is declared, not constituted. In any case, the expression is very common in America, probably due to the influence of secular laws. There are three sources of matrimonial nullity: defect of form, impediments, and defects of consent. Only one of these three things can make marriage null. In this lesson, we are going to see canonical form and impediments. The following three lessons will address the defects of consent. 3. Form. Canonical form is a requirement for Catholics who can only marry in the presence of a minister and 2 witnesses. The requirement was introduced by the Council of Trent for the validity of the marriage. Until then, marriage in secret was forbidden but possible. It was illicit but not invalid. This distinction between valid and licit is important in canon law. If a requirement for validity is not met, the act is invalid. But if the requirement is only for licety, the act is valid. For instance, celebrating Mass without chasuble is forbidden, but the consecration would be valid. Using beer instead of wine is forbidden, and that consecration would be invalid. Canonical form is observed when the spouses exchange consents before a qualified witness or official of the Church in the presence of 2 witnesses. The qualified witness receives the consents in the name of the Church. The law assigns this role to the pastor in his parish or to the ordinary in his jurisdiction. Ordinary is a technical word in canon law. It means the bishop of a diocese and those who have executive power because of their office, like the general vicar, for instance. Other bishops, presbyters, or deacons can assist weddings as qualified witnesses, but only if they have received the proper delegation or faculty from the local pastor or ordinary. This delegation, a very common practice in the Catholic Church, is required for the validity of the wedding. The witnesses are 2 humans able to testify that the wedding was celebrated. They don't need to be Catholic or even Christian, but they need to have sufficient use of reason. Notice that canonical form does not require a physical church. Ultimately, canonical form means that 5 people gather for the wedding: the spouses, the minister, and 2 witnesses. Celebrating the sacrament of marriage in a sacred place is a requirement of licety. Celebrating the marriage in the canonical form is a requirement of validity. Non-Catholics, baptized or not, are not subject to canonical form. They celebrate marriage in their own way. Catholics can only get married through the canonical form. All other nuptial celebrations, civil or religious, do not create a true marriage when at least one of the spouses is Catholic. Canonical form is dispensed every now and then for very special cases. When the dispensation is granted, Catholics get validly married outside of the canonical form. Essential defects in canonical form make marriage null. This happens, for instance, when the priest does not have delegation or when there are no witnesses. These marriages are invalid and can be declared null through a judicial process, as we have explained above. Many times, however, Catholics attempt a merely civil marriage. We call these cases lack of form. Unlike defects of form, these cases do not require a judicial process. There is no need for a trial to establish the freedom to marry of Catholics who attempted marriage outside the canonical form. When this happens, it is enough with the prenuptial investigation that must be performed before every marriage. However, given the diversity of religions and the widespread use of civil divorce, American dioceses typically reserve these cases to the chancery. In Atlanta, lack of form cases are instructed at the Metropolitan Tribunal. 4. Impediments. The impediments are 12 laws that render marriage invalid in some special situations. Impediments make invalid a consent that would otherwise be valid. In other words, they render juridically inefficacious a naturally sufficient consent. These laws produce the invalidity of a very specific and limited number of marriages, aiming to protect determinate values. Since they limit the right to marry, which is an essential human right, they are limited in number, only 12, and only the Holy See can establish them. Some impediments are expressions of natural law, and therefore cannot be dispensed. The other impediments can be dispensed. If the impediment was dispensed before the wedding, it ceased to cause its effect, and the wedding was not invalid because of the impediment. In real-life tribunals, we rarely see most of the impediments. In the last few years, we have only addressed prior bond, disparity of cult, and abduction. Prior bond is the only one that we use frequently. The other two very seldom. In our disparity of cult cases, the priest forgot to ask for the dispensation. Our few abduction cases come from some parts of Mexico where the horrible practice of stealing the bride is still common. Age. According to Canon 1083, males under 16 and females under 14 are not able to marry. This canon has raised some criticism since these ages are shockingly young. By no means does the Church promote early marriages. Canon 1071 prohibits marriages below the age allowed by civil law and marriages of minors without the parents' consent. Canon 1072 instructs the pastors to advise against celebrating marriages at younger ages than those common at the prelates of celebration. These ages of 14 and 16 are nothing but a legal reflection of the age of puberty, which normally marks the acquisition of the minimum of capacity to consent to marriage. Marriage is not a difficult feat reserved for the elites. It is a basic human right, deeply rooted in our human nature. Impotence. Impotence is not the same as non-consummation or infertility. Impotence is the incapacity to perform coitus, in the man or in the woman, and must be antecedent, perpetual, and certain. Antecedent means that it must exist before the wedding and at the time of the wedding. Perpetual means that it cannot be cured by licit, ordinary, and non-dangerous means. Certain refers to the moral certainty, which excludes the probability, but not the possibility of the contrary. Bond. According to Canon 1085, someone who's married cannot remarry. This prior bond is any valid marriage, whether sacramental or not. Note that the impediment is based on a valid marriage. If the prior marriage was merely putative, that is, invalid, there is no prior bond. Only a valid marriage makes the successive marriage null. In other words, the impediment of prior bond operates depending on the truth of the marriage, not on the apparent status of the person at the time of the successive marriage. Disparity. This impediment is called disparity of cult or disparity of worship. According to Canon 1086, a Catholic cannot marry a non-baptized. The disparity of cult is different from the prohibition of mixed religion, according to which Catholics cannot marry non-Catholic Christians. The disparity of cult is an impediment. In these cases, the dispensation is required for validity. On the other hand, mixed religion is a prohibition. In these cases, the permission is required for liceity. In other words, without dispensation, the wedding of a Catholic to a non-Catholic Christian is valid, but it is invalid if the Catholic marries a non-baptized. To be sure, the dispensation from both the impediment and the prohibition is granted often. Orders. Canon 1087 invalidates the matrimonial consent of clerics, that is, bishops, presbyters, or deacons. This includes permanent deacons when they become widowers. Only the Holy Father himself can grant the dispensation for this impediment. Vow. This impediment, as we can read in Canon 1088, operates when the party has professed a public and perpetual vow of chastity in a religious congregation. Therefore, it does not affect a private vow of chastity, for instance, professed in the internal forum with a spiritual director, a temporal vow in a religious congregation, or a vow emitted in a society of apostolic life or secular institute. Abduction. Canon 1089 establishes that a woman cannot give valid consent to marry her abductor, even if she is willing to do so. Until she is separated from her abductor and established in a safe and free place, her consent is invalid. This impediment does not apply to abducted men. Crime. Canon 1090 causes the nullity of the consent of those who kill their own spouse or the spouse of the other party with the intention of marrying him or her. It also causes the nullity of the marriage of those who conspire to kill a spouse with the purpose of obtaining the freedom to marry the other spouse. Consanguinity. Canon 1091 regulates the validity of marriages from the perspective of the blood's related parties. Natural law prohibits marriage between siblings, parents and children, and grandparents and grandchildren. Since this is a precept of natural law, it cannot be dispensed. Moreover, ecclesiastical law forbids marriage between cousins and between aunts or uncles and nieces or nephews. This precept can be dispensed. Due to the higher mobility and the smaller size of families, marriage between cousins are not that common anymore. But the dispensation of this impediment used to be relatively common until recent times. Affinity. Canon 1092 regulates the impediment of affinity. This impediment is basically like the impediment of consanguinity, but based on a valid matrimony. The relatives of one's spouse are affine in the same degree and line as they are consanguine to oneself. For instance, a widow cannot marry her former husband's cousin without a dispensation. Propriety. This impediment, according to Canon 1093, produces the invalidity in the same terms as the impediment of affinity, but based on an invalid marriage or mere cohabitation. Thus, in the prior example, the intended marriage would need a dispensation even if the prior marriage was declared invalid or if it was mere cohabitation. Adoption. Canon 1094 produces the nullity of the marriages between parents and their adoptive children, and between those who became siblings through adoption.